Hello friends, today we're going to talk about case management conferences. I know a lot of my colleagues and attorney friends and their clients hate case management conferences. Well, you know what? I love them, and I'm going to tell you why in a minute. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. Many of you may be sitting there wondering if I have finally caught the kook because I came out here and I said that I love case management conferences. Well, let me explain why. And before I do, remember that each jurisdiction is different, so I invite you to check the statute. I hope that there is. But for those of you in Florida, the case management conferences are governed by Florida Family Law Rule of Procedure 12.200 subsection A1 and reads as follows. A case management conference may be ordered by the court at any time on the court's initiative in which the following may be ordered at said conference, and it lists 6 areas or 6 things that may be ordered, and we're going to go into all 6. The first thing that a court may do at a case management conference is that it may schedule or reschedule the service of motions, pleadings, and other documents. Specifically, if there are some temporary motions that are pending that are kind of in the way of the case getting to a final hearing, the court can schedule those temporary motions for hearing. Examples of temporary motions include motions for temporary child support or time sharing, for temporary alimony, or temporary attorney's fees. In addition to this, if there's some motions for enforcement pending or motions to modify previous orders, there may be issues relating to the children that are pending. The court can also order the parties to attend mediation as one last opportunity to try to settle the case between them. So this is a very powerful tool because what the court will do is it will take away any of the temporary hearings that are pending that will prohibit the court from getting to a final resolution in this case, and that's very powerful. Second thing that the court can do is one of my faves, and it can set or reset the time of trial subject to a particular rule. You ask for a case management conference because the case has been pending for a couple years. You get up in front of the judge and you ask the judge to set the trial that you're ready to go. And what's great is at that point, the court will schedule a trial, and oftentimes will let you know how long the trial is going to be, whether it's going to be a couple hours, like 2-hour trial, or if it's going to be a couple days, like 3, 4, or 5 days. It will also set due dates if the court issues a trial order for pretrial catalog, conferral requirements with opposing counsel, when discovery will be closed, and when exhibits are due prior to trial. So this is a great opportunity to get in front of your judge and push your case along. The third thing that the court can do is coordinate the progress of the action if complex litigation factors are present. So I'm going to try to explain what some of these complex litigation factors may be in Florida, starting with high asset divorces. Divorces involving high net worth or couples can be complex due to the large number of assets and properties that must be divided by the court. This can also include issues related to the valuation of those assets, tax implications of the property division, and the division of business interest. If one or both of the spouses owns a marital business and the court considers it to be a marital asset, if the court's going to divide that asset, then a business valuation has to be completed, and it's typically performed by a qualified expert. The expert will review all of the financial details and all the relevant information about the business, and then the expert will give an opinion as to what the value of that marital component is and how it should be divided by the court. Another example of a complex litigation issue may be international divorces. Divorces involving parties from different countries can be complex due to issues related to jurisdiction and some cultural differences. Also, retirement and pension benefit cases. The division of these types of retirement and pension benefits can be complex, especially when both parties have significant retirement assets and the percentage share of the other spouse's interest has to be calculated. Child custody disputes. Sometimes those cases can get complicated, especially when a guardian ad litem is involved. Also, cases involving parental alienation, there's a relocation case, and finally, cases involving domestic violence. The fourth matter that the court can resolve at a case management conference is to limit, schedule, order, or expedite discovery. This is every attorney's favorite. If interrogatories, which are written questions that one party sends to the other requesting information about the case, aren't completed, the court may order them to be completed. Request for production of documents for either financial records, tax returns, or bank statements. Depositions. Depositions are oral examinations conducted under oath in the presence of a court reporter. Request for admissions. Those are a request for statements under oath that one party asks the other. And then there's other examples of subpoenas. It's a legal document or a legal order that seeks or requires a third party to provide certain documentation. And finally, anything relating to any expert witness appointed to the case. The fifth matter that can be addressed by the court is the court to schedule the disclosure of expert witnesses and the discovery of facts known and opinions held by such experts. A lot of these cases, there are different types of experts that can be appointed in a case. Some financial experts, such as forensic accountant or a regular accountant, can provide analysis as to the party's financial statements. A child custody evaluator may provide the court with some sort of report. These are mental health professionals or a guardian ad litem that will make a recommendation regarding custody. There are real estate appraisers. These are people who go out and appraise the real property of the parties, whether it's a marital residence or a rental unit or an Airbnb. There are business valuation experts, which we touched upon a little bit before. There are vocational experts. Vocational experts are key in alimony cases. The vocational expert will provide an analysis of the spouse who is requesting alimony, their earning capacity, and the job opportunities that they have in a particular community. And then there's mental health professionals. These are all experts that may be on a particular case, and the court may order these experts to provide orders or reports. Make sure that all of these experts are getting the information out to the parties necessary to get the case to trial. Finally, the court may schedule or hear motions relating to the admission or exclusion of evidence, whether they be motions in limine, motions to allow the minor children to testify, for minor child hearsay. There's a slew of issues that can be addressed and scheduled at a case management conference that will help streamline the evidence that comes into a trial. So that's a wrap on what a court can conceivably do at a case management conference in Florida. So if you see that your case is set for case management conference, hopefully this video has provided you with some important information that will help you push your case to the end and get it resolved at a final hearing. So if you know anyone that has a case management conference scheduled soon, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando. Se habla español. Please do us a favor and like this video, subscribe to the Divorce Broadcast, and we will see you again soon. Don't sneeze at case management conferences. Thank you.